I'm now going to share my slides that we'll speak to today. And can you see those? Hopefully you can.
Yep, they're up on my screen.
Thank you very much. Thank you. So now I just need to click on. So just a bit about Burkitt's really. This is Burkitt's at a glance. We are quite a sort of, top 50 law firm, 90 partners, based primarily in the east of England, but now have offices in London, Sevenoaks, and Adducing, no doubt. And and we're a full service law firm. Admit. Oh, busy.
It's all right, I'll do the admitting.
Great, thank you.
So it doesn't.
I'll just press one. So today you have your speakers today are delivering the briefings, and they will change as we go through the different sessions. But today you have me. I'm Abigail Trencher. I'm a partner in the employment team, but I also head up Burkitt's professional regulatory discipline team. And I'm joined by Tom Sharpe, legal director in our team. And I recognise some faces, so I've certainly sat on panels with some of you, but not all of you, and so maybe go for Tom.
Yeah.
So today we thought we'd start with the rules of evidence, which is just, what you have to look at as panellists. So that's what we're going to look at in this period. And the idea is we're going to run for about 40, 50 minutes, and we should have time for questions afterwards. So at this point, I'm going to hand you over to my colleague Tom, who's going to take you through the agenda and get us going. Tom.
Excellent. Thank you, Abby. So if you want to just click on to the next slide, we'll tag team it that way. So as Abby said, first of all, delighted to welcome everyone to the session. Really hope you find this useful. It is our first of these sessions, though. So if you've got any feedback at the end as to the level we've pitched at, if you think it's too low, too high, please let us know and we can adjust accordingly. What we wanted to do, though, because we're mindful that a lot, if not most, panelists that we deal with don't have a legal background, we thought it'd be really helpful to start off this series of webinars just looking at the rules of evidence and trying to cover off some of the basic groundings that we as lawyers, we are legal advisors, to panels. So rules of evidence issues that we as lawyers perhaps think are straightforward or which are obvious to us because we're dealing with them day in, day out. But we thought if we cover off the basics and then have a slightly deeper dive into some of the more pertinent issues, look at some of the recent case law, that would hopefully give a good balance to the session, something for everyone. For the experienced pros in the audience, the first half might be more of a reminder of things you already know, but for those of you that are perhaps a bit more new to panel work, this will hopefully be a useful introduction. So I drew the lucky straw. I get the slightly more basic element to start with, and Abby drew the short straw. She gets the slightly more techie case law bit at the second half. So it's on the.
And I'm just going to, and I should have mentioned it before, but as I've just mentioned to Tom, I am actually at home today because my dog's just had an operation. So I'm on dog care duty. But unfortunately, I hadn't really realised that at this time, people will be coming home from college and so forth. So the dog might bark. So I do apologise. But hopefully, fingers crossed, not too much.
It's the joys of modern webinars. Okay, so I won't go through what's on the slide because you can hopefully all see it. But essentially 2 halves, intro and then case law. So Abby, if you want to pop onto the next slide, please. So first question, evidence, what is it? Why is it needed? And again, I won't read out everything on the slide, but the point is evidence is any information of whatever form that's relevant to the facts and issues in dispute. So it could be oral, it could be documentary, it could be copy evidence, it could be emails, it could be audio recordings, it could be CCTV evidence. It's anything that, as lawyers, we would say has a probative value. So it's something that, in this case, as panelists, you can look at, listen to, read, which will assist you, hopefully, to determine the issues that are before you. So that's what is evidence. And why is it needed? So it's needed to assist you to prove the case that you are considering. Just some general observations. So first of all, we're talking about rules of evidence in the context of civil procedures. Now, TRA panel hearings are dictated by specific rules and regulations, so the advice and the procedures, which hopefully you're all familiar with, and there's legislation that underpins that. But essentially all of that is based on the civil procedure rules themselves. So that's why we have based this session on the civil procedure rules themselves. We have got one slide just to talk very briefly about slightly different rules that apply in the criminal courts, just to alert you to the fact there is a slight difference, but essentially it's the civil procedure rules that we're talking about. And the overriding trend in all of the case law there is towards a relaxation of the rule of evidence. So what that means in practice is that there is a presumption that information will be included, will be adduced or admitted, and you might resolve issues of relevance later on. So the starting point is you're probably going to let it in. And again, if you've sat on panels and you've had disputes over admissibility, you'll know that the procedures address, and they have provisions that apply where there are disputes of evidence, and there's timetables for when you should identify a dispute over it and how it should be resolved. But ultimately, it comes down to a question of fairness, and there's a concept called the overriding objective that applies, which is if you're having to resolve an issue, you are fundamentally looking at, is it fair to do it in one way or another? So it might be, yes, a document's been adduced or provided a little bit late, but it is relevant, and neither party is going to be significantly disadvantaged by it being allowed to stand, in which case you're going to allow it in. So those are just some general comments around evidence, why is it needed, and what your operating presumption is, i.e. towards admission. So different types of evidence. Again, we could drill down into a much higher level of detail here if we wanted to, but we just wanted to focus on the key points. So just going through the different types of evidence, what's real evidence? Well, real is actual evidence. So it is the photo that was taken, it's the recording, or it is the actual CCTV footage. And sometimes you'll hear about real evidence described as primary or secondary evidence. So real evidence presented in its primary form is the original copy. It is the photograph that was taken. A secondary piece of real evidence is a photocopy of that photo. So it's still the same photo, but it's not the original. So just in case you come across it. And then you've got more obvious things like documentary evidence. It's the staff handbook, it's the report that was raised at the time. Oral evidence, well, that's the evidence that was presented during the course of the hearing itself, and usually that will be on the back of a witness statement, which we'll talk about in a second. Sometimes we have expert evidence. In my experience, not all that regularly in TRA proceedings, but other types of proceedings, it's far more common. And then finally, hearsay evidence. Now, Abby's going to talk about that in a bit more detail later on and look at some of the case law. But it's just worth mentioning at this stage that although it used to be the case many years ago that hearsay evidence wasn't admissible, that's no longer the case. So nowadays, hearsay evidence is admissible, but generally you will afford it lesser weight. So might still be relevant and you might still take it into consideration, but you won't place as much reliance upon it as opposed to direct first-hand evidence from a witness who's attended and given their evidence. And just to be clear, when we talk about hearsay evidence, fundamentally hearsay evidence is second-hand evidence. So it's someone that hasn't witnessed something, but someone has told them what happened and they're reporting back what they were told. So that's hearsay evidence. They're not a direct witness of fact. But it's important to clarify that it also extends to people who perhaps provide a witness statement that's included in the bundle that's placed before you, but they don't then attend the hearing to adduce oral evidence to substantiate their witness statement. That will also be hearsay evidence. And it is important to understand that, because it has, as I say, less probative value. You can still admit it, you can still take it into account, but if someone's just put a statement in but not supported it with oral evidence, then it's pretty much it's not as valuable. So next slide, please, Abby. So how do we adduce evidence? Well, ordinarily, I'm sure you're all familiar, you will have a bundle of documents presented to you at the start of the hearing. Ideally, it would have been provided in advance and you'll have had the opportunity to read through it. And in base case scenario, it will have been agreed between the parties in advance. Isn't always, but ordinarily it should be. But that alone is not sufficient to adduce that evidence before you. Simply because you've got an agreed bundle of documents doesn't mean you necessarily place reliance upon it. There is a specific process for adducing that evidence so that you can place reliance upon it. And in broad terms, it's outlined on the slide. So it's for a party wanting to rely upon a particular piece of evidence to raise it with the adjudicating body, whether that's court, tribunal, or in this case, you as the TRA panel. So you'd have it in the bundle, but you would then ordinarily cross-refer to it in your witness statement. And in the course of the witness statement, you would confirm, you'd say, included in the bundle at page whatever is the statement I provided to the investigating officer, and I confirm it's true, or you would provide some further explanation. So that way you specifically raise it, verify what it is, and confirm it's accurate to the tribunal, or here the panel, and that way you can place reliance upon it. Sometimes you'll see exhibits in witness statements. Again, that's a way of adducing the evidence if it's perhaps not already in the main bundle. So the primary way in which, certainly in TRA hearings, evidence is adduced is via witnesses presenting that evidence. And the running order there is they'll have provided a witness statement, which again should have been provided and exchanged in advance. Those statements are what we call taken as read. So they don't have to read the statements out during the course of the hearing. It's assumed that everyone's already read them and understands them. And then there's broadly three types of questioning that happen. So there's evidence in chief. So you've provided your witness statement. Your representative might ask you one or two more questions about that evidence if something's arisen since you provided it, or just to clarify a particular point. That should be relatively brief. Then you will go over for cross-examination. So the other side will ask questions about your evidence and test your evidence. That should take up the majority of the session. And then it's not on the slide, but just worth mentioning, there is a process known as re-examination, which is where if you said something typically in cross-examination that's perhaps at odds with your witness statement, and your representative knows that you've got confused or you've said something that was wrong, they might ask one or two questions and redirect you to a part of your evidence to clarify it for the benefit of the court or the panel. Now, in more formal settings, so the court or the tribunal, re-examination is usually pretty rare and very limited. TRA panels are much more informal, and in my experience, re-examination is more common and is permitted. But you know, you don't really want to be giving a party a second bite at the cherry. They should give their primary evidence and their evidence in chief, and they should have answered it in cross-examination. So if you find you've gone through cross-examination and then a party's representative is starting to ask reams and reams of questions, that ought to be a red flag. So next slide. please, Abby. So we've talked about how you adduce evidence and what evidence is, but how do we know whether we should admit it? Well, a two-stage test applies there. So first of all, is the information relevant? Secondly, is the information admissible? So relevance is, as it says on the slide, judged with reference to the issues of fact that are in dispute in the case. And that term is interpreted quite widely. So information can be directly or indirectly relevant, and it doesn't necessarily have to be definitively proof of one thing or another, but it does need to be relevant to the question that you've got to determine, even if only partially relevant. But it's interpreted pretty widely, and in most cases you'll have a statement of agreed facts, which should be in the bundle, so you'll know whether something's already been admitted, in which case you don't need evidence about it because there's nothing for you to resolve, or if it remains in dispute, and that's what the evidence should focus on. Once you've determined that evidence is relevant, the question then is it admissible? And in 9 times out of 10, the answer to that is going to be yes. There are certain exclusions. Again, they're set out on the slide. So, evidence should be evidence of fact. It shouldn't be an expression of opinion. So if you're getting information, a statement that's just someone saying what they think about something, well, it might be relevant, but it's not going to be admissible because it's just their opinion. The only exception to that is if they're an expert and they are expressing an opinion within their sphere of expertise. Alternatively, sometimes in the course of witness statements, people will explain why they say something happened in a particular way, but that's not necessarily opinion, that's more explaining how they formed a particular perception. So they might be saying, I'm not quite sure how it happened, but I think it happened this way. Slightly grey area between opinion, perception and evidence. There, you're probably going to err in favour of admitting it. We've referenced legal professional and without prejudice privilege. In a nutshell, communications between a lawyer and client in the lead up to or in preparation for litigation, that's not admissible in proceedings because it's confidential between them, it's legal advice. Similarly, without prejudice, as if there's been negotiations to settle, they wouldn't be included, but that's not going to be relevant in a TRA context. We've just also mentioned public interest immunity and evidence obtained by torture, neither of which really, again, are going to be particularly relevant. I've already talked about hearsay and the presumption that that's admissible now. My final point on this slide is just to say, don't confuse relevance of evidence with weight of evidence, because not all evidence is equal. Evidence might be relevant and it might be admissible, but certain types of evidence have greater weight than others. So if you've got direct first-hand evidence, you're going to afford that a high weight. Whereas if you've got second-hand or potentially hearsay evidence, or maybe character references, both of which Abby's talking about a little bit later, so I won't steal her thunder, but those are types of evidence that you can take into account and may enable you to make your decision, but you're more likely to afford them lesser weight than other evidence, because they're not first-hand, they're not direct evidence. Next slide, please, Abby. So just briefly, not going to talk too much about this slide, but essentially, the points to take away from this are that under the civil procedure rules, courts and tribunals have a wide power to control the evidence that's presented to them, to admit or exclude evidence. And much the same applies to you in your role as TRA panelists. The procedures do afford you a very wide discretion. You can make directions at case management hearings and at the outset, and indeed during the course of full panel hearings. and there are specific rules set out for that. If at any point you're in any doubt as to whether evidence is admissible, relevant, what weight should be afforded to it, that's the sort of thing that you can ask us or whoever, if anyone else that's appointed as the legal advisor, just to get some advice on that particular point, and we will have advice that we can provide. And you don't necessarily have to wait until after an application has been made or until the end of a particular stage of the proceedings. You can ask that at any point if you've got any concerns. And I mentioned this a little bit earlier on, but again, I'll just flag it. It's the third point on the slide. Individual professional conduct panels, such as the TRA or General Medical Council, whatever it might be, will be governed by their own procedural rules. We've already mentioned that the TRA rules that apply. But often there'll be what as lawyers we refer to as a lacuna, which is basically a gap in those procedures. So it doesn't fully or comprehensively address a particular scenario. The fallback position there will ordinarily be you would look to civil procedure rules, or in the event that it relates perhaps to sexual misconduct or any form of criminal prosecution, you might look at the criminal rules of evidence to determine whether the information that's presented to you should be admitted, whether it's relevant, and if so, what weight should be afforded to it. Next slide, please, Abby. So how do you verify evidence that's presented to you? In civil proceedings, often parties will go to great lengths to verify evidence. So they might have a handwriting expert to prove that someone wrote a document, or they'll obtain IP address information to verify that an email was sent by a particular person. In practice, those sorts of lengths are not gone to in TRA proceedings. More often than not, you will have a party exhibit a particular document or cross-refer to it in their witness statement, and then it'll be a case of asking them, well, did you write that email? You know, is that your signature at the bottom? And you verify it that way during the course of their oral evidence. But you do need to verify the evidence, particularly if it's something that you're going to place material reliance upon in making a decision. And if there is a dispute over the evidence, again, there's provisions within the procedures to assist you to resolve that dispute. And in some cases, you might resolve it by saying, well, we're not going to admit that evidence. But again, more often than not, that overriding objective, that presumption of fairness and admissibility, is that you'll probably allow the information to stand, but you'll afford it much lesser weight because of the fact that it is a disputed document or a disputed piece of evidence. So that principle of fairness, again, kicks in. That the rules are there, but the discretion is afforded to you as the panel to do what you think is right overall. So that was all I was going to say on that slide, Abby, if you wanted to skip over. So this is the final slide for me before Abby gets into the more nitty-gritty. It's just to mention that there are slightly different rules for evidence of a criminal nature. I'm not proposing to go into masses of detail about it. Suffice to say, fundamentally, they operate on the same principles. Is it relevant to the issue in dispute? Is it appropriate to admit it? There's perhaps greater consideration for probative value and ensuring it's not prejudicial to a party to have the evidence admitted, but otherwise the issues are fundamentally the same. It's the sort of thing, though, that if there is a dispute, again, the legal advisor will give you specific advice during the course of the hearing. Okay, so that's all I wanted to say in terms of general comments. I'll let Abby take over now for the rest of the session.
Thank you, Tom. So, as many of you all know, when receiving legal advice from your legal advisor, they often spout case law at you. There's not many lawyers that are not very excited by case law. It's one of the reasons why lots of us came into the profession, because we have a very, very good system of jurisprudence in this country where, you know, the courts make law. So one thing might go into statutes and legislation, but quite another might come out from a court's interpretation of the situation. So what we're going to do now is we're going to look at the key recent, so I'm looking at the most recent cases on particular issues that relate to the rules of evidence. So the first case comes in versus General Medical Council, which is a 2019 case. Now, Dr. Kumzin was a Ukrainian national who was working and training in the UK as a GP. Concerns were raised about his training as a GP and his fitness to practice, and conditions were imposed on him as part of those concerns. But in the meantime, Dr. Kumzin had applied to provide out-of-hours services to separate service providers, and he failed to inform the out-of-hours service provider of those conditions. And he was subject to a medical practitioners tribunal referral. Dr. Kumzin partially accepted the allegations but refused to give evidence at the hearing. So what this case determines is, what do you do when you look at your rules of evidence and your key subject of the regulatory concerns chooses not to give evidence, as Dr. Kumzin did? Well, the High Court held in this situation that the disciplinary tribunals can draw an adverse inference from the silence of an individual charged with breach of the regulatory system. So as Tom has taken us through, as that individual has refused to give evidence, his evidence cannot be challenged, he cannot be subject to cross-examination, and the panel is not able to hear from him. And because of that, you can draw an adverse inference. However, before you do that, panels should always consider whether it wouldn't be procedurally unfair to do so. And that requires panels to look at if there's any circumstances in play that would mean it would be unfair and unreasonable to draw that inference. And in general, no inference should be drawn unless a prima facie case to answer has been established, the individual has been given notice, and appropriate warnings been given that if he does not attend to give evidence, an adverse inference may be drawn. There is no reasonable explanation from him not to give evidence, and there are no other circumstances in the case that would make it unfair to draw an adverse inference. And in this case, this might be familiar to you, that they're often what you consider when someone doesn't actually attend. But Dr. Coombs in this case had attended, he just refused to give evidence. And so again, even in those situations, an adverse inference can be drawn and impact on the evidence. So now moving to look at the authentication and production of evidence. So under the civil procedure rules, a party is deemed to admit the authenticity of documents that have been disclosed unless they're challenged. So when you receive that bundle, you would often see at the beginning of it whether or not there has been confirmation given that that bundle has been shared with the subject of the referral, and whether or not they have disputed any documents in the bundle. And if they have not done so, if they've not challenged the authenticity, and yet they've had an opportunity to do so, then that bundle of documents should be accepted in and should be deemed to be evidence that the panel can consider. And that follows the civil procedural rules, because unless a notice to prove documents has been provided at the trial, then the courts will accept documents in the bundle into evidence. And it's quite trite law that civil cases and the courts can expect all the parties to proceedings, to agree in advance a bundle of documents. And the same holds true for professional conduct matters. And the procedures, certainly those that apply to the TRA, are quite clear. The process of disclosing documents to one another and the bundle being given to the subject of the referral in advance of the hearing. So unless someone challenges any documents, if they're in the bundle and they've been disclosed in advance, and there has been an opportunity given to challenge the authenticity of evidence, then it should be acceptable to accept them into evidence. However, there are commonly issues in respect to professional conduct hearings where the subject of the referral may just go off the radar and not cooperate or respond at all. So they haven't accepted them all, and it goes by way of a PCPM, for example, that they won't attend, but the bundle will be considered. This is where an individual just hasn't cooperated or responded at all. Now, in that situation, the panel won't have any clear notice that the individual has considered the bundle and has had the opportunity to dispute and challenge documents. So in that situation, the panel may want to review the evidence and to have it adduced to them. And as Tom said, that might be that you would expect a witness from the regulator who's giving evidence on behalf of the regulator to explain to the panel what certain documents that are being relied upon are, and how they came to be, and to confirm their validity and their authenticity that way. So Tom's already mentioned that admissibility of evidence is quite different from the weight and priority that evidence should be given. And that is something that professional conduct panels will always have to consider when weighing up all the evidence at the end of the evidence stage, and before it considers, obviously, its decision. And the High Court, in the most recent case on this, of Talganskasi, and I probably completely mispronounced that, so I do apologise, but versus the General Medical Council, which is a 2021 case, Mr. T, as I'll conveniently refer to him, was a surgeon referred to the Medical Practitioners Tribunal for failings which had led to the death of a patient. And here, the GMC wished to include a coroner's report. And Mr. T did not challenge the inclusion of that report at all, but clearly it was relevant because it related to the coroner's findings in respect of what had led to the death of the patient in question. And the High Court was very clear in that case that regulatory proceedings such as the GMC are quintessentially inquisitorial, and noted that under the GMC's procedures, the tribunal could admit any evidence it considered fair and relevant, and stated that the relevancy principle does not apply to inquisitorial regulatory proceedings. So as Tom's already said, this case and the judgment confirms that in respect of professional discipline matters, the panel can decide to admit evidence where it considers it relevant and fair to do so. But this case also deals with the weight to be put on that evidence. And what is clear from the High Court's decision, which looked at other cases, one being Queer, which you would be referred to, I'm sure, by your legal advisor, is that whilst it might be admissible, the weight to be put on it should be determined by all the other evidence. And what is clear is that there is no presumption that just because a coroner in this case, but it could be another court in another, has made a judgment relevant to the facts that might be before the professional conduct panel, that does not mean that the panel should accept that judgment as a finding of fact of itself. It's not any suggestion that another judgment, or in this case the coroner's report, was a prima facie proof of fact would be rebuttable. It has to be weighed against all the evidence before the panel, and that includes any evidence that the subject of the referral would put forward to try and obviously dissuade the allegations. And that's very important, because from because it's seldom the case that the allegations before, for example, the TRA will be the same as the allegations or the charges that may have been put to the same individual in relation to a criminal matter and a criminal court proceedings. And relevant cases that you might be referred to by your legal advisors concern a divorce petition that was put in. That's one of the first cases on this, and then judgments that have appeared subsequently in respect of a subject who's been subject to criminal proceedings. And I certainly have had this come up where we've had other proceedings. One that I can recall related to a first tribunal who was dealing with an appeal in respect of the DBS. And then another was in respect to the family court. So all those documents might be admissible, but the weight needs to be weighed up in respect of all the evidence that the panel should go on and to review and consider. So in the case of Dutta,
Abby, just before you go on, just because we've had I saw a couple of questions flash up, so I'll just briefly answer those if I can. So they were all to do with, at least as I saw, to do with convictions, and it's just worth mentioning that if there has been a conviction of a specific criminal offence, then the panel will accept that certificate of conviction as conclusive proof of both the conviction and the facts necessarily implied by the conviction, and that's page 8 of the advice. So where you've got a conviction, a certificate of conviction, you can rely upon that. Similarly, if someone's accepted a caution, then that is effectively a clear admission of guilt that's relevant. So it doesn't carry the same weight as a conviction, but it will carry significant weight. You should contrast that, though, and this is kind of an extension of what Abby was saying, with you will ordinarily have information of the finding of the school, typically dismissing the teacher in question. And what's clear there is that you shouldn't be influenced by the decision the school made. You can take into account the evidence it obtained, but simply because the school determined it was a gross misconduct offence, you should afford that very little to no weight. You have to make the decision yourself. So hopefully that just picks up those couple of questions that people raised. So sorry to interrupt you, Abby. I'll let you continue.
And we should have made that distinction. So yes, so certificates of conviction and a conviction itself, a finding of that the actual offence happened is one thing. I'm referring to other court cases that are relevant but not strictly on the same allegation. So for example, family courts, if something's been referred to the DBS and that has then been appealed. So it's where there's other judgments and a coroner's report, as in the case of, so where they want to insert it as relevant, it's for the panel to determine the weight to be put on it.
And it's much the same. I mean, often we'll have people refer to other TRA decisions and say, well, there's a precedent set there, and you should consider that as relevant evidence here as to the sanction and findings that you should reach. And again, the guidance is very clear there that it doesn't have any precedent value. So it's certificates of convictions that you can place specific reliance upon, and potentially other specific judgments and findings of fact. But otherwise, it's for you as a panel to determine the evidence as you see fit.
Yeah, thanks, Tom. Looking here, and we're looking at the weight of the evidence to be given to witness evidence. This is like priority evidence, and the Dutta case and the summary that it gives of preceding judgments is really helpful. And the case of Dutta versus General Medical Council is a 2020 case, and here Mr. Dutta was a cosmetic surgeon, again referred to the Medical Practitioners Tribunal, and he appealed and brought a judicial review in the High Court. And the High Court confirmed that it could only interfere with findings of fact made by tribunal in limited circumstances. But in respect of the appeal ground that dealt with the weight of witness evidence, the High Court summarised the previous judgment, particularly in the case of Gessman versus Credit Suisse, where It was this really really helpful quote, which is, "We believe memories to be more faithful than they are. Memories are fluid and malleable. Events can be recalled that did not happen. The process of litigation subjects the memories of witnesses to powerful biases. Considerable interferences with memory are introduced in the procedure for preparing for hearings. Statements are often prepared long after the events to which they relate." And therefore concluded that the best approach is to base factual findings on inferences drawn from documentary evidence and known or probable facts. So when you're weighing up the evidence, the important thing is to look at the objective evidence that's the most contemporaneous. So that may be notes of meetings and minutes of meetings that took place around the time of the incident. They will be the oldest and the most contemporaneous. And actually witness evidence, particularly that obviously as this case alludes to, which can be quite remote from the actual date of the incident to which they're referring, less weight should be put on those. So Dutta went on to, the High Court in Dutta went on to confirm that tribunals should start with the objective facts shown by authentic, contemporaneous documents, then consider oral evidence to subject those documents to critical scrutiny, because that's the opportunity of both the panel and the parties to cross-examine the witness on those documents and issues that arise from them. And panels should not give any over-reliance on witnesses' demeanour in assessing evidence. And there have been other cases on this, that the witness demeanour, how they come across at hearing, panels should not place too much weight on that. Assess the evidence in the round to determine whether the relevant regulatory body has discharged the burden of proof. And this will entail grappling and resolving any conflicts of evidence and any inconsistencies which may undermine the credibility of a witness. So what panels need to look at is the evidence in the round, and if they have received evidence from a witness in oral evidence, then you're looking at any inconsistencies between that evidence and the documentary evidence, and or any other oral evidence given by any other witnesses, which is why it's really important that all the witnesses' evidence, the statements, are exchanged, because that allows both parties the opportunity to be appraised of the evidence that a witness is going to give, and that evidence can then be challenged and put to other witnesses. And if witness statements are not fully prepared in advance and exchanged, then the parties whose witnesses come first, they have the disadvantage, because that evidence, the evidence that will come later, hasn't been put to that witness, and panels can't put that evidence, any inconsistencies, to witnesses if they don't know that evidence is yet to be put before them. So it's really important that panels are, alive to any inconsistencies between documents and evidence that's been given, or oral evidence given by several witnesses, and do challenge those inconsistencies. And in the case of Khan versus General Medical Council, they also looked at this issue about witness credibility. And in the judgment in Khan, the panel kept going on, and note to legal advisors how to write a decision, kept talking about, the demeanour of the witnesses. They were so confident, they were so certain. And actually, the High Court was very critical, because what they're saying is that it should not have placed such reliance. So what they say here is the court confirmed that the panel should avoid making assessments on a witness's credibility exclusively or significantly on their demeanour and or their confidence. Panels should instead consider, as part and parcel of its determination, all of the evidence which goes to the question of credibility. And in fact, in Dutta and Khan, they're so dismissive of this demeanour and overconfidence that the point was actually made that the more confident your witness, the more worried you ought to be, because it really isn't a test of how good your witness memory is. So we're now going to touch upon hearsay evidence. Tom's already touched upon it, but it is dealt with in the Civil Evidence Act 1995, which defines it as a statement made otherwise than by the person while giving oral evidence in the proceedings, which is tendered as evidence of the matter stated. And references to hearsay include hearsay of whatever degree. And evidence shall not be excluded on the ground that it is hearsay. But I would just underline the point that Tom made earlier, which is hearsay can often be, oh, I heard so and so said this, or I didn't see it for myself, but I was told very soon afterwards that by X that it had happened. Or corroborative evidence, or capable of being corroborative evidence, even though that individual had not heard it firsthand. But as Tom made the point, it also relates to statements that are put into evidence, but which cannot be tested because the individual has not actually attended to speak to their statement, to give oral evidence. So the admissibility and weight in regulatory proceedings of hearsay evidence was addressed by the Nursing and Midwifery Council and by the High Court, who heard an appeal by Ms. Thornycroft, and they set out the relevant principles which emerged from previous authorities. So the admission of a statement of an absent witness should not be regarded as routine, and panels need to consider fairness before admitting into evidence a witness statement from a witness who will not be attending in person. And the fact that the weight should be attached to it will be determined by the panel is not of itself sufficient to make it fair to admit it. Before deciding whether to admit a witness statement from a witness who will not be giving evidence orally before the panel need to consider the existence of good and a cogent reason for the non-attendance of the witness. Or is there a good reason why they're not attending? And if the evidence is the sole or decisive evidence in relation to a particular charge or issue, the decision as to whether to admit it requires the panel to carefully assess all of the competing factors, including the other evidence to be called and the consequences of admitting it. And the panel must be satisfied either that the evidence is demonstrably reliable, or alternatively, there will be some means of testing its reliability. Now, this is difficult because we know when dealing with the TRA that they don't often use witness orders, and they often have situations where witnesses do not come forward. They submit statements, and they might have statements that actually they prepared around the time of maybe the disciplinary proceedings, but they don't actually attend in person at the hearing, and it is very difficult. And sometimes we've had cases where that evidence has been very pertinent to the allegations that the teacher is facing. And it's very difficult for panels to assess, but it is important to go through the test of understanding why the witness is not attended, and then to decide, in the round, how important is that evidence and what is the consequences going to be of admitting it. And admissibility was dealt with two other recent cases. So El Karut versus Nursing and Midwifery Council in 2019, where again they make this point that admissibility and the weight to be put on evidence is two very separate issues. And in Shagang Shipping Company Limited versus HNA Group, the High Court then the Supreme Court held that where there is an issue as to whether important hearsay evidence is admissible, it is a logical approach to determining that issue first before going on, if the evidence is to be held to be admissible, to consider its weight and its evidential impact on the substantive issues to be determined. So if you are being asked to admit evidence that's hearsay evidence, and what we usually see is because the witness is not going to turn up, then you should always consider first whether it's fair to admit it. And then you would move on to the stage 2 test of weight. Now, in the Criminal Evidence Act, at Section 4, it states that in estimating the weight, if any, to be given to hearsay evidence, the court shall have regard to any circumstances from from which any inference can reasonably be drawn as to the reliability or otherwise of the evidence. Because of course you need to be mindful that it cannot be tested. And that was looked at further in the case of Hovid Limited, Mr. versus Loughton, a civil case in the Employment Appeals Tribunal. And in that case, it's quite interesting because actually it was in favour of the hearsay evidence, because what the Employment Tribunal had determined is that it had to find that there was almost no case to answer where the evidence from the employer that these two that Mr. Loughton had been smoking his company car was not available to be given in person at the hearing. And instead, the only evidence they had was that given by Mr. Loughton himself, and he absolutely denied smoking in his company car. And the judge therefore said that in the absence of evidence in person from the respondent's witnesses on this point, it was not possible to find as a fact that Mr. Loughton had been smoking in the car. And the Employment Appeals Tribunal was very critical of that decision, and they said that the judge should not have gone that far, that there is no rule that hearsay evidence cannot be considered or given weight, and it should consider the fact that witnesses in person have to be given evidence under oath affirmation, and their evidence can be tested in cross-examination. So that's likely to affect its weight because they're not there to be challenged and they haven't given that evidence under oath. But that doesn't mean that it should be thrown out in its entirety. And the weight to be attached to hearsay evidence is to be considered by the judge, by the panel, and that does not mean that such evidence should be ruled out from consideration, or to conclude that in the absence of evidence in person, a finding in respect of the respondent or indeed the regulator is simply not possible. So you can see that that case is quite that you really, you might choose to admit it, and you might then consider the weight that you need to be put on it when looked at in the totality of all of the evidence, and looking at documentary evidence and seeing, for example, any inconsistencies or if it's completely consistent. They're the things you'll be looking at. Again, going back to basics, looking at your documentary evidence and then using the other evidence to subject that to scrutiny. And then lastly, just going to conclude with good character evidence, because that is also admissible. And the leading case on that is Wisson versus Health Professions Council. And in that case, it determined that evidence of good character is not just not to be admitted and to be given weight in respect of whether or not the individual, for mitigation purposes, but it can be used for credibility, to question whether it was likely that the individual would have got up to the misconduct with which they're charged. And it can also be an indication that it would be less likely for that individual, because of their good character, to have committed the conduct in question. So so good character evidence can go to credibility and propensity. I have to say, in regulatory proceedings, though, unfortunately, you rarely get good character evidence given in person. It tends to be at the back of the bundle because it is going to be used for mitigation. But it shouldn't be assumed that it's for mitigation, because that good character reference, if it's very strong, and particularly if someone actually comes to the hearing to give good character reference, can be quite persuasive, and the panel can consider the weight of it in respect of both the credibility limb and the propensity limb. But on that point, I'll just give a little word of warning that arose from the Khan and General Medical Council case I referred to earlier. And in this case, there were several charges, all on very similar themes or similar misconduct in respect of conduct towards separate witnesses. And the legal advisor in that case provided a cross-admissibility direction that if the panel found an allegation proven in relation to one complainant, they then could determine whether they should be satisfied that that established a propensity on his part to engage in unwanted sexual touching, as that case was, in respect of the other complainants, i.e. once you've found in favour of one allegation in respect of one witness, that could show a propensity and therefore a likelihood that he would have carried out the same conduct in respect of the subsequent witnesses and complainants. However, the High Court in that case, who did have criticisms of the investigation and the court's decision and the decision that was reached by the practitioners tribunal, held that the problem with the admissibility direction is that if the decision taken by a panel when adopting that principle in respect of just one of the complainants and the charges with which they found that there was then a propensity to act in the manner in question, if that is found to be flawed, then unfortunately it brings down their decision in relation to the other charges on which they based their decision, because they'd based it on the propensity and the cross-admissibility principle. So the warning there is, if you want to, and if you do consider the cross-admissibility principle, i.e. that there is therefore evidence for propensity to act in a certain way, it should not be the sole or primary reason for finding an allegation proved, because if it is, then if the first one topples, your subsequent decisions on finding a fact might also topple. And then I'm just going to leave you. We just thought we'd leave you the TRA's procedures and an overview of the standard proof, and that the most recent case there, well, the one that's the strongest case on which I think sets out clearly the burden of proof is REH and sexual abuse standard proof in 1996, and in that it just says the balance of probability means that a court is satisfied an event occurred if it considers that on the evidence the occurrence of an event was more likely than not, and that the seriousness of the allegation and the seriousness of the consequences should not affect that standard of proof. You just look at basically what the likelihood is and weigh up all of the evidence before you. So I hope that was helpful. We should have time for some questions if you have any further ones. So thank you very much. And if you're interested in attending the next in the series, that will be on sexual misconduct. It's going to be around June. We will be posting the date of that on our website shortly. And that will be followed by conduct outside of the profession and insight and remorse. But if there's any other topics that you would like us to cover in one of these briefings, then we'd be really grateful to hear from you, and we'd entertain that too, because obviously these are the ones that we think are of sort of greatest interest, but we could be wrong on that. So please let us have your thoughts. And if you have any feedback for us, we'd be really grateful to receive it. Thank you. I'm going to stop sharing my slide. And do we have any questions? No, I think
I can see Duncan's got a hand up. I've just had a quick look through the chat function. I can't see any other questions, or at least what I think we've addressed the ones that were raised. If anyone thinks otherwise, please do shout. But Duncan, do you want to launch with your question?
Yes, thank you. I was halfway through typing it out, but I thought at the end I'd just ask it. I know that the number of witnesses who are available to come to talk to a panel can sometimes be necessarily limited because of the time available, the availability of witnesses in the same time period, and so on. And so quite often, and I think the TRA's rules as well say that they normally will only allow someone who's accused of breaching professional standards and so on to bring 2 witnesses unless they apply in advance and it's considered necessary for them to have more witnesses. This is for face-to-face hearings. And I think that it's my understanding that partly that was because of the cost involvement as well when everything was face-to-face. And I wonder if that is relaxed now that mostly it's done by video. But my real question is, if we are only seeing some of the witnesses, the ones who are available, coming to us in person or on video, but actually giving oral evidence and being available to cross-question and so on, is that a problem, or should we not worry about that? And the ones who we're seeing are the ones we need to see, and that's all we need to know. Yes,
I mean, you are an inquisitorial panel, but you have to deal with the case that is presented to you. I'm not, I mean, certainly, and we have collaboration meetings and meetings with TRA, and I'm not aware that there's issues that have arisen because witnesses have not been available, or sorry, that there's too many witnesses. Usually the issue will be sort of a lack of witnesses that are willing to attend. So I don't think that there should, well, I'm not certainly aware of an issue where the TRA have curbed a teacher's ability to bring witnesses along. And if that were the case, then the teacher could very easily apply for a decision on that, and that would probably be referred to a CMH for a panel to determine whether or not that witness should be admitted. And almost certainly, I think I'd be very surprised if they refused, unless, of course, it was deemed that the evidence they were going to give was just not relevant. And I think that is an issue in respect of good character evidence, because I can see that good character evidence, it's not pertaining to the actual facts in issue. It's more a case of does this person have the propensity, and whilst it's relevant, you wouldn't want to hear too much of that, so you wouldn't have to which is probably why in respect of good character evidence there's sort of an acceptance that if you write a statement, it will be admitted into evidence and won't be challenged, but it'll be given the weight that such evidence is given, because it can't be challenged. But that's usually the only area where I suspect that there might be some pushback about the attendance of a teacher's witnesses.
Yeah, and of course it's for the TRA to prove their case, so up to them to have the right witnesses available and to the
yes, and we know that they struggle because the delays, of course, mean that witnesses have often moved on with their lives and don't want to come back. And of course, the issue with the TRA is the critical age of the witnesses, particularly, and that is a difficulty.
And I think that leads us neatly on, if it's all right, Duncan, to a question that Sue's raised, which is a recent case, the concern that key witnesses weren't present and gave their statements little weight. However, the teacher's rep did not challenge admissibility. Should the panel have? And I mean, personally, on a number of cases I've been involved in, I've been surprised that admissibility arguments haven't been raised by teachers' reps. There's just been an acceptance that witness statements relied on by the TRA in the bundle are just accepted. And I would say the panel does have an obligation to test the evidence before it. And if it's concerned that statements are of critical importance and there aren't, and that witnesses aren't attending in person to adduce evidence orally, then that is something that it can properly raise with the teacher's representative to see if they want to raise any issues about it. Ultimately, it is for the representative to say if they admit the evidence or not. As Abby said earlier, if in the event there's no challenge, then it's deemed that admissibility is conceded. But it is still open to you as a panel, as I said in my slot. You do have wide powers, and you could determine that if evidence is absolutely crucial and the witness is not going to attend to stand behind it, you might say, well, we're going to exercise a power to adjourn, or say we simply can't reach a determination in this case. So you have got that wide power. You wouldn't necessarily want to use it too lightly, but I can see there are. I mean, I had one case which ultimately didn't go ahead in the end, but we had two critical witnesses who had given a statement but then said they didn't want to attend, and I had raised and said, well, how can we possibly make a decision without this evidence? Because it goes literally to the heart of the case. It was a he said, she said case, and these were two witnesses were the only people that could verify whether it was he or she that had said it. So without them, we were going to be in real difficulties. And as I say, it didn't go ahead in the end. But yeah, you've definitely got that autonomy if you wish to exercise it.
And also, in order to determine weight, I mean, it does go to obviously, admissibility, but certainly in weight, I think the panel can ask to understand why the witness has not attended. There might be good reason, but I think you can inquire as to that and to what steps have been made to ask them to attend. Because you've got to put weight on their evidence, and it is sometimes difficult to do that when it on the face of it looks compelling, but then they haven't followed up and been prepared to actually come to the hearing. And of course, now we have remote hearings. Special adjustments can be made for witnesses that don't want to see the teacher. So I think you can ask those questions yourself and probe if the teacher's representative, because quite often the teacher might not even have a representative, and they often have not much of an idea about the procedures, and they really struggle.
Thank you.
Excellent. Right, I can't see any more questions popping up. I think you've got our contact details on the slide, so if there's any burning issue that comes to mind immediately after the session or shortly afterwards, then do let us know. I'm sure we'll be happy to pick that up. But otherwise,
Yep.
Abby, unless there was anything else you wanted to say, I was just going to say thanks everyone for attending. I hope you found it useful. If you've got any feedback, we definitely welcome it. But otherwise, yeah, look forward to seeing you at the next session.
Thank you. Have a nice evening. Thank you.
Thanks,
Right.
Abby and Tom. Cheers.
Thank you
Bye.
very
Bye-bye.
much. Thank you very
Bye.
much.
Thank you. Bye.
Bye.
Bye.